Ready? All right,
Yes,
we'll
sir.
call the meeting of the May 2017 Real Estate Appraiser Commission to order, please. I want to thank each one of you for your time and your commitment to the commission. We have to call roll.
Thank you. Randall Thomas,
Here.
Rex Garrison,
Here.
Mark Johnston,
Here.
Dr. Warren Makara,
Here.
Rosemary Johnson. Here. And that is the full commission at this point. Thank you.
It does give us a quorum.
Yes, it does.
Okay. We want to adopt the current agenda, which is found on page 1. Anybody have any questions, additions, or subtractions? If not, hear a motion to adopt the agenda.
I move to adopt the agenda as presented.
Second.
Motion's been made and second. Any further discussion? All those in favor say aye.
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 All those opposed? Agenda has been adopted. Thank you very much. On page 3, you'll see a review of the minutes from January 11th, which was a conference call. Was not?
January 11th, we had the ASC people here.
Okay, my error. It's on page 3. Please review that. Any corrections or additions to it? I guess I have a question. Do we have minutes from our conference call?
You do. It's following that
Okay.
one and
Okay.
page 27. And that's the reason at the conference call, we only did complaints, and so we didn't motion and approve the January meeting. So we'll need to do both this time.
Okay. I need a motion to approve, first off, the January 11th minutes.
I make a motion that we approve the January 11th meeting, 2017 minutes.
Second.
A motion and second. Any additions or subtractions from it? All those in favor say aye.
Aye.
All those opposed? Motion carries. Thank you very much. Now, the February meeting, which was, or March meeting, which was via conference call. It's on page
27?
27.
I move to approve the March 29th, 2017 minutes.
Second.
Motion been made and second to approve our conference call minutes for March. Any additions or subtractions? All those in favor say aye.
Aye.
All those opposed? Motion carries. Thank you very much. We'll move on to reports from experience interviews. Mr. Garrison?
Met with Corey Hammonds this morning, discussed his 3 reports, and we went over a few things and constructive criticisms, and I make a motion, or I approve his reports for the upgrade.
All right, motion's been made to approve the upgrades for Rex's, or Mr. Garrison's interview. Second?
Second.
Motion been made and second. Any discussion? All those in favor say aye.
Aye.
Any opposed? Motion carries. You just have one, Rex? You got another one? Mr. Johnstone?
Yes, I had the opportunity to interview Melissa Rich, who was applying for a certified general license. And during the interview, a couple of things came up. And so I kind of thought that I might have a way to work through this, but I'm not 100% sure. So I want to bring this and let the commission kind of meditate upon it as we go through this. So anyway, Miss Rich became a trainee in 2012 and submitted a log with that had income producing properties and so forth on it. That and she has 3 sponsors, of which one of the sponsors in the income producing properties that were all done in early 2016. During the interview process, I found out that she had only went to the site inspection and building inspection, and that's the only thing she did in the entire report. But she has signed the certification, but did not sign the letter of transmittal, which is highly unusual. I would think you just get significant professional assistance, but the sponsor told her that the reason he did not want her to sign the letter of transmittal was due to the fact that it could be potential litigation, and he did not want her to be exposed to that. And my thought was, you sign a certification, you're already exposed to that. So any lawyer worth their weight's going to subpoena you as well, and subpoena you first, most likely. But she said her sponsor was adamant about that. The other report, that was on a proposed. It was an auto dealership, not proposed, here in Nashville. The other was on a Music Row property that she signed the certification, did not sign the engagement letter, but basically she didn't do the research on that either. The sponsor had done most of that, although she did participate a little bit more in it, but not to a little bit more than she did in the prior one, where she just made the site inspection. The third report was an eminent domain report that she had prepared with her sponsor, and another sponsor, not the sponsor on the income producing properties, but one of the income producing properties on Music Row had a leased fee estate and a fee simple estate. And I asked them about the leased abstract, who prepared that, and she said he did. And she said, but I was sitting there during the preparation of it, which I'm okay with that. But she just really had not demonstrated that she knew all of that. But so I said, well, tell me about the eminent domain report, because it was for the city of Murfreesboro, did not have any of the data sheets were not in there. So if you're doing it for a property owner, you'll put the property owner data in there for them. So I didn't have any of the sales to look at aside from what was in the grid, which that might, she said the rest was in the brochure, and I understand that. So I asked her about how they came up with the land value, and she said, well, there was a tract of properties together, and they came up with $10 square foot and just applied it to every one of the properties. And I understand, makes sense. But I said, well, how did you come up with that? Did you verify? Did you find these sales, verify these sales, confirm these sales? And she said, no, they had already been done, and for the project, for other tracks. And I said, what? She said, I worked on the improved side, as more so. And I said, what'd you do on that? I said, did you locate, confirm, write up the improved sales? And the answer again was no, they were already done. And these reports were impeccable. There's no standard 2 problems. There were no standard 1 problems. It's because she had great sponsors. It's just, I don't think she did much of the work. So then I said, well, look, how about you send me, let's look at your log and get 3 reports that you've done in the 2017, because she said after she went to work for the third sponsor, of which was one of the reports she had submitted, he turned her loose to do it all pretty much. I said, perfect, let's see those. And then, and I said, she said, well, we did another right-of-way project. And I said, well, what kind of properties were on that? And she'd indicated it was a mostly single family and 1 church. I said, okay. I said, send me the entire brochure. And she said, the single family and the church are not on the log sheet because they were done after the log was submitted. I said, well, I'd like to see the brochure start to finish. She said, well, it's 100 and blah, blah, blah pages. I said, I don't care. I said, you told me you did the entire brochure. I want to see the entire brochure, and I want to see the church and the house. And I said, and I'd like to see two other reports of income producing properties that are not eminent domain or right-of-way projects. And she said, well, I don't have any of those since I went to work with him full-time. That's all we're doing. I might have one, or I might have one. And she said, the reason I don't have any is because I took all my classes to get my CG from like August. She said, I just went straight through class to get my work done. And I said, well, it sounds to me like you're just trying to fast track it as fast as you can, which I said, that's admirable and all that, but I'm unclear as to what, I mean, I know you're a smart person. You passed the test, you passed all these, but I've not seen a report that demonstrates your ability. And the sponsor was sitting in there with us, you know, and he didn't say much. I didn't want him to. I mean, I wanted to see what she knew. And so I'm kind of at a loss, because if she submits the 3 reports, and I wanted to get the log from the staff to be able to pick something that was done under the sponsor, she said turned her loose, to try to find an income-producing property. But what questions I have prior to that was, what about her contribution and work effort to the experience that was all done in 2016 by the sponsor that she admittedly said she just went and did a site walkthrough with? Do you get full credit for those things? I don't know how we move forward on this. That's my report, Mr. Chairman.
Thank you. Could you repeat that? I just have a question. Most people have a problem getting one sponsor. Were hers consecutively, or?
Well, I asked her how she got into the business, and apparently she had family and relatives in the business.
Okay.
They were primarily residential appraisers.
Yeah.
And she wanted to get into the commercial side. So then she got a commercial sponsor, and then she got another commercial sponsor. I don't know whether they were no, they're all right now, because on her resume lists all 3 sponsors. So I'm assuming, based on that she still has those 3 sponsors, unless one said, I don't want to sponsor you anymore. And these appraisers are competent appraisers. They're very good appraisers. There's nothing wrong with the work. It's just I don't know what she actually did. And every time I would ask a specific question, I could not get a specific, detailed answer. It was more broad stroked.
If you were to receive the work that you've asked her for, could you make a decision at that time?
I told her, I mean, I hate for somebody to have to drive, you know, in from out of town. So I suggested, let me look at those reports, and then if they look fine from a standards perspective, and she and I can have a phone conversation, and I can ask her specific questions about how she put the If that's the case, then I could make a verbal recommendation to staff that that's okay.
Okay.
I mean, I'm okay with that, but what about all of the reports that were done prior to that we know she didn't do much of the work on? How do you give experience? I mean, I don't know. I mean, and I told her, I said,
And who goes over those experience credits?
Right now, Dennis does review the experience credits and the information, but I think he would not have caught anything like this.
Yeah.
So it's vital that
did you sign an
the
affidavit
reviews-
at the bottom of that?
Correct.
That you have done this report?
that you did it. Yeah. So I don't know how we really fix that. If that's not what she's doing right now, she may.
I mean, you know, and if it came to, and she said, okay, these reports from when I became a sponsor, sponsored by this individual, to this date, I did not, you know, do all of this. You know, here and submit some more, or maybe we need to deal with why would you sign an affidavit that you did it when you didn't. I'm just kind of I'm uneasy about the whole situation, to be quite honest.
Well,
But I do think she's a quite smart, competent young lady, and there was nothing. I think she just wants to get her CG as fast as she can, and I can appreciate that. But I mean,
Have a recommendation to bring to us?
Well, my recommendation is to look at the other three reports, and if they look acceptable, we move forward on that component. But the previous component about getting experience for reports that you didn't do anything but walk through the site with, maybe you shouldn't get the full credit. Maybe you should only get something less than full credit because you did at least go to the site. So if it's a 30-hour job and you spent 3 or 4 hours over there, maybe you get 3 or 4 hours rather than the full. But so I don't know. I'm asking, and then those were the ones that the certification was signed, but the transmittal letter wasn't signed. So, somebody that's signing a certification in my office, they've contributed just about everything to the report. If they're just doing 1 or 2 little items, they don't sign the report. They're getting significant contribution to the extent of this and that, which we talk about in the scope or whatever.
Sure.
So I just
Go back to what you said a while ago, though, was any attorney that was worth his salt. I don't know why, but that gives me the impression of some kind of misrepresentation or something as to why she's signing one section but not the other, because she's involved, and like you said, she's going to be involved whether she
that was
signs
the
that
sponsor's
transmittal or
reasoning
not.
That was the sponsor's reasoning for not
Sure.
allowing her to sign. And I mean, she's kind of got her hands tied. The sponsor
Sure,
says,
understand
and the owner of
that.
the business says, you're not
Yeah.
signing.
Right,
I understand that, but I don't think that protects him or her.
right.
But moreover, the fact that she may not have contributed to that, and I don't know the USPAP. I don't know if we have a clear understanding of signing a certification indicates you did it all or you did some parts of it. I've never read that where it says how much you've done. But I know in my office, if you're going to sign it, you're going to be able to testify to pretty much how the whole thing went down. Although USPAP, I don't think dictates that. So I don't know if you could say she violated USPAP. I don't know that you could say she violated USPAP, but it also gives you on the log, you don't have to automatically take the maximum amount of hours. You can take something less than that if you feel you did less than that.
Sarah?
So
I'm gonna give you this real quick, so we think it goes under this rule, maybe she shouldn't get full credit.
that's what I think, because you can get,
You have to perform 50% of the work on the appraisal report to get full credit. But
Okay.
she did it,
okay,
so,
here's my recommendation.
so you
I
may have to
think.
go back and look at her whole log again.
Here's what I think we need to do. I think based off of this, I think that the staff needs to send her a letter referencing this chapter and saying that you cannot get full credit for something if you had only done less than 50% of it, which we know a site inspection, a walkthrough, is not even 5%. So she should probably go back and reevaluate her log from her and anything that was not at least 50% of, then has to. Now she can still get partial credit though for that.
Yeah, I think so.
And
yeah.
the partial but the ones that she didn't do 50% on, she needs to go back and do whatever the reasonable, appropriate partial credit was, and remind her that she's signing an affidavit, that says this is accurate and it's not to be misleading or fraudulent. And then let her see if she has enough hours accumulated to even come back for the experience review. If she does, at that juncture, then we choose 3 more reports.
I'll have her bring you the three reports
Right.
that you requested.
And I think that's,
And if it's between meetings and she really does meet the timeline, we can get it to you
I can
sooner.
still do
And
that.
if the
I can-
commission's okay, we can proceed if that's the
Right.
case.
right.
That might be your best bet to do a motion that says, once they review it, if she has the credit, we'll get you the 3 reports, and then they can approve your recommendation upon review, if you want to do it that way.
Okay, so the committee recommendation would be that she reevaluate her log that she submitted and make sure that it meets the criteria as outlined in 1255-03-.02 criteria for standard and review appraisal experience, and then resubmit it subject to that standard. Understanding that there is a signed affidavit involved with that submission of that
That's in the form of a motion. Do I have a second?
I'll second.
Motion's made and seconded. Any further discussion? All those in favor say aye.
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 Any opposed? Motion carries.
Now, my follow-up to that would be that in the event she does have the adequate hours for review, that 3 more reports are submitted, and that those reports that are submitted are from her most recent sponsor, Mr. Peck's log sheet, and none of the others. And that that I'm given the opportunity to choose those 3 reports. One of which she's already stated is an eminent domain project in Smyrna with a church and a house as 2 of the tracks. So we know that would be one. And then the other 2 would be some type of income producing property.
We want to, do we need that in the form of a new motion, or can we just include that in the old one?
Oh, and with those being done, if I review those and they're acceptable, then I can make a verbal, I can make a call to the state to approve that credit so that she can move forward without
so-
having to come back to this body.
Okay, so that needs to be, that's a motion.
That is a motion,
Okay.
a recommendation, excuse me, from the committee.
That second?
A second.
All right, we have a motion second. Any further discussion? All those in favor say aye.
Aye.
Any opposed? Motion carries.
Can I ask one question?
Sure.
Is there a way that you could put that in an email and send to me so that I can just forward?
That concludes the experience interviews. Education, Dr. McCara.
Well, we received 23 course proposals and 6 individual course proposals. 21 of the course proposals are for continuing education only. 2 of the course proposals are for both qualifying education and continuing education. All 23 of the proposed courses are presented by means of traditional classroom instruction. And each of the 2 courses that are proposed for both QE and CE include 2 additional hours for the exam. All 8 of the individual course proposals are for continuing education. In the interest of complete information, I should mention that a couple of the courses, specifically courses 2024 and 2029, 2024 and 2025 from Brian Reynolds. One of the instructors, John Austin Hicks, whom
Yep.
maybe some of you know or do not know, but anyway, he did indicate that he had been found, he had been disciplined by, I guess it was this body, for some sort of a illegal type case like that we review, but I believe that the only form of discipline he received was having to take a course in report writing. Former Director Avers was supportive of his continuation. So I don't think that there was any problem with that, with the instructors for the 2 courses he's involved with, both of which are on basic appraisal principles.
Let me stop you right there.
Sure.
Does anyone have any questions of Dr. McCara about Mr. Hicks? Go ahead, Dr. McCara.
Okay. In fact, I would mention, too, for consideration, because often when we do our when we go through our legal cases and we come up with recommendations for courses for people to take to get them up to speed in issues where there are violations, 3 of the courses here I think would work very well for that. 2 of them I've already mentioned, the courses 2024 and 2025 on basic appraisal principles. I think that would be, if someone is found lacking, either or both of those courses would be highly recommended. The other one that we've often recommended for some of the legal cases we've reviewed has to do with report writing, and there's a very good course that was among the ones that I reviewed this time. It's course 2029 from the ASMRA on report writing. So might want to sort of make a mental note of that, or more than a mental note, that when we have situations that involve, yeah, this person needs to take a course in report writing, that's one we might consider. Otherwise, I recommend all these courses and individual courses for approval.
I need to recuse myself from one of them. I'm a approved instructor for one of
I
them.
won't hold that against you, though. Of course.
Okay, have a motion from Dr. McCary to have a second.
Second.
Okay. Any further discussion on education? We'll be approving all these courses at one time. All those in favor say aye.
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 All those opposed? Motion carries. Thank you, Dr. McCary.
Mr. Chairman,
Yes, sir.
I need to cover, and I didn't realize this is covering interviews prior to today's meeting. I conducted a couple interviews in my office because we didn't meet in March. So I have a couple that I need to pass on as far as experience reviews.
You can go back to that page 47 on your iPads. We'll make sure to motion each one.
47?
Yes.
This happens again, we'll have to let you go. No problem. Go ahead, Rex.
The first one, Robin Melton, met with her at my office, reviewed 3 reports, found those reports to be acceptable, and approved her for her upgrade. Are we going to take these one at a time?
Yes,
Okay.
please.
Motion to approve.
Okay. Motion been made. Do I have a second?
Second.
Motion been made and second to approve Mr. Garrison's experience interview with, what was her name?
Robin Melton.
Robin Melton
Robin Melton.
is the first one.
Okay. Robin Melton. All those, any further discussion? All those in favor say aye.
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 Any opposed? Motion carries. Mr. Garrison.
The second one, Drew Presley Gall. I met with him in my office prior to today's meeting, reviewed his reports, and I found those to be acceptable and recommend his upgrade for licensing. He's going from a trainee to a certified general.
Make a motion to approve.
Second.
Motion been made and second to approve Mr. Garrison's experience interview. Any further discussion? All those in favor say aye.
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 Any opposed? Motion carries. Thank you, Mr. Garrison.
The final one, Jason Keith Nobles. I was sent his reports. There was a question as far as the amount of hours he received in a short amount of time, also within the 30-month period. Also, the 3 reports submitted did not reference any assistance as far as him working on those reports. I recommended that he, and also those reports had some age to them. So I recommended to him that he resubmit 3 current reports for review.
So we do not have a decision to make on him yet?
I have a
Okay.
decision.
No decision on him yet. All right. Anything else?
And that's it.
All righty.
Since we're on this, if I could just add, we've got a report with Mr. Eric Collinsworth, and so for the next meeting, we will have a new board member. He is no longer on the commission, and so I know we will all miss him and thank him immensely for all the service he provided after even his expired term. So I will check into the date of the reports that he reviewed. If in fact it's, before he received his letter, we'll bring it to the next commission, but we hadn't received anything in writing until Friday regarding the change.
Thank you very much. Next on the agenda is a director's report. Roxana?
Thank you. It is on page 52 of your iPads, and so we so far are tracking along. I didn't have anything out of the ordinary to present. The format you all have had a chance to look at. Hopefully by our next meeting, we'll definitely have the fiscal year closing with any of the cost backs, in actual numbers and be able to start comparing it with the trends at the bottom. So that is as of just March 2017.
You don't have any kind of motion or anything to make?
No, this is more information to make sure that we're on top of
Okay.
what it looks like. Absolutely.
Chairman?
Yes.
Can I have a question for the
Sure.
director? Do we have any idea or any, of any additional board members to help us out here?
That is a great question. So it was nice on Friday to get the appointment, because I know that, for the July meeting, and we'll talk later on about the number of meetings we want to hold and our 2018 dates with Mr. Collinsworth, it was, just hard sometimes for him to make them. So we are hoping to get 2 more appointments soon. I know they're in the works, but we don't have them yet. It's a great question.
All righty. Anything else? Thank you, Roxana.
You're welcome.
Legal report.
Morning.
Ready?
I'm Erica Smith, and I've taken over for Dennis Gregory as he's been gone on military leave. So this is my first appraisers meeting. So bear with me and let me know if I need to do anything different. Starting with number 1, this is a represent. Do you want me to read just the new information and the case number, or how would you like me to?
Is there new information that we haven't been presented?
Just new information with our attempts to retrieve the further information that we've put off. We've put this case off for 2 meetings, so I was just going to go over how we tried to obtain that and what our result.
Sure, you can read the number, the
Okay.
case number, and then tell us what you want.
So case number 2016057481 and 2016057482. So these were both presented in January 2017 and then again presented in March 2017. So the new information, at the March 2017 meeting, the commission requested that council obtain the scope of review information. Since the March 2017 meeting, a paralegal with our division emailed Respondent 2's representative on March 7th, 2017, requesting a copy of the contract between Respondent 2 and the lender. Respondent 2's representative responded on March 16th, 2017, stating that Respondent 2 performed services to qualify, select, and manage the appraisal process as an appraisal management company. Respondent 1 conducted the field work and expressed her opinion of the value of the subject property in the appraisal report, and the issues brought forth in the complaint are only related to the appraisal and the appraiser's competence. Therefore, Respondent 2's representative stated that council needed to contact Respondent 1 or the appraisal firm to request any documentation. As a result, the paralegal then called Respondent 1 and left her a voicemail requesting she provide the scope of review that the lender had requested. That same day, the paralegal also left a voicemail for the complainant requesting the same information about the scope of review. Respondent 1, Respondent 2, and the complainant have failed to provide the information regarding the scope of review that the commission has requested. The new recommendation is to dismiss both cases against Respondent 1 and Respondent 2.
Okay. You've heard, and we've been over this a couple times, this complaint. You've heard recommendation from council to dismiss both of them, number 1 and number 2. Is there any discussion?
Why would we've been, through this pretty heavily for the last several months. Why would we just all of a sudden dismiss it?
When I read through it, obviously I wasn't available or here to hear the discussions the first 2 times, but when I read through it, I didn't see any violations that we could really go after, or any penalties to assess.
Ready? Mr. Johnstone?
So as of right now, with regard to AMCs, we have the new law coming on board, and then we'll go through a policy making, is that right?
Yeah, and I kind of went through all of the AMC statutes that are currently out there and went through all of the civil penalties that you're allowed to assess for. And there's nothing that this AMC would fall under. I mean, we can't tell them you have to respond to us. They don't have to respond to us. They could have just ignored us from the beginning. But most of the stuff that we can go after them for is failure to register, which is unlicensed, or if they don't pay their appraisers, or they try to get them to change information on it. So,
Well, I guess my question is, I understand that on respondent two. but
I would go
management
with the
company-
letter of warning.
But
I mean, on
respond,
one.
but respondent one,
Yeah.
you know, is an appraiser, so we do have authority over them, and they did have some pretty, or had noted violations. So what is your recommendation? Why are you recommending to dismiss respondent one? Under respondent two, yes, I agree with, but respondent one, what's the rationale on that?
I haven't received any information or documentation to show that there was violations. I'm not sure what Dennis.
Hey, Erica, I can tell you.
Okay.
So I presented this in January.
Oh, okay.
And it was reviewed by an expert review, and I believe there were 1, 2, 3, at least a handful of violations that I didn't think were super serious, but I thought that she needed a letter of warning to just hit those high notes on that letter. But
Am I allowed to amend
yeah, you
my
can tell 'em, yeah.
recommendation? Okay. I mean, after speaking with you and hearing Sarah's, I will amend my recommendation to dismiss the complaint against respondent two. And the recommendation for respondent one is the authorization of a letter of warning and regarding the use PEP violations that the expert reviewer spoke about in his report.
Okay, we have a amended suggestion from council. Any discussion on that? Yes, sir. Would you recognize me? Sure. Okay.
Just had to, didn't you?
I had to do that. I got to tell you, this complaint was filed equally amongst two people or two entities. One's a AMC, one's an appraiser. I understand that. I would be of the suggestion we ought to do exactly the opposite. I think the letter of warning needs to go to the AMC, although I realize we're not allowed to do that. If they had any kind of quality control, this individual probably would not be having a complaint filed against them. So I oppose your second one and would like to stick with the first one, but we're going to go with the second one. Okay, so I don't want you going back and forth, but they weren't major violations, and if they had any kind of quality control, I would think that AMC could have come back and said, hey, could you fix this, do this, do this? Not that I've ever had an AMC call me and say, could you straighten out something, or could you correct something, or do this or do that? So I'm opposed personally to your amended
Okay.
requirement. So anyone else have anything to say?
The letter of warning would not constitute disciplinary action, though.
No, but my
So-
problem with
No, I
that
mean, that's
is-
what I'm saying. I don't want
Yeah.
to, based on what you're saying, we want to make sure that respondent one is not heavily handed, too much. And respondent two, who should be, we can't do anything about.
No, I understand that. I just don't like the fact it goes in your file and stays there.
There were violations noted, so there has to be some recognition of that.
Oh.
And I think a letter of warning is about as heavy-handed as we want to be without saying, well, we're going to ignore the hard work that the reviewer went through, et cetera. So I think that's an appropriate.
Okay. All right, you've heard a recommendation from council. Any further discussion? The recommendation is a letter of warning for complainant one and dismissal for complainant two. Any discussion? All those in favor say aye.
Aye.
All those opposed, yes. Okay. One. Yeah. Motion carries. Number 3, please.
Number two,
Oh, I thought number 2 was the
I think
AMC.
it was included in,
Oh, okay,
in
I'm
number
sorry.
one, but
I'm sorry.
technically it is the third complaint. But number two on the legal report 2017-012-921. And then would you like me to read? These are all new, so would you like me to read the summary? Okay. Complainant filed complaint with the Department of Commerce and Insurance on February 24th, 2017 against respondent because respondent had not paid complainant for an appraisal performed in May 2016. Complainant is a licensee who accepted an assignment from the respondent on May 11th, 2016 at 4:58 p.m. to inspect, measure, and take photographs of the subject property. After returning from the inspection, there was a cancellation notice on complainant's email. Complainant then emailed respondent to inform them that they still owed the complainant half of the fee, totaling $225. Complainant states that respondent stated they would pay the complainant's fee of $225. Respondent did not pay the fee. On August 29th, 2016, respondent requested complainant complete another assignment, and complainant reminded the respondent that the first assignment had not been paid for by respondent. Respondent stated they would overnight a check to complainant. Complainant proceeded with the second assignment and sent the report to respondent, but never received the check for $225 for the first assignment. Respondent responded to the complaint stating respondent scheduled an inspection for May 12, 2016 at 12 p.m. Respondent provided a copy of the automated notification that was emailed to complainant at 10:45 a.m. on May 12, 2016, along with a status update in the portal to put the appraisal on hold. It is standard practice to notify appraisers of all appraisal updates via email and through the website portal. Typically, no compensation will be received by an appraiser that is notified that an appraisal is put on hold and still completes the appraisal. Respondent states since the appraisal was put on hold so close to the actual appraisal scheduled time, respondent made a good gesture and paid complainant the $225 that was owed from the first assignment. Respondent provided a copy of the check for $225 that was sent to the complainant on March 6, 2017. Therefore, the issue becomes moot because the complainant has been paid and we have proof of it. So the recommendation of council is to dismiss.
Okay, you all heard the complaint. Any discussion? All those in favor of council's recommendation, say aye.
Aye.
Any opposed? Motion carries. Number 3, please.
2017-013-561. Complainant's mortgage company retained respondent as well as the respondent in the complaint 2017-013-621 below for what complainant states as an evaluation on complainant's home in order to stop private mortgage insurance payments. According to the expert reviewer who counsel requested to review respondent's quote evaluation, the quote evaluation document that complainant provided is actually a comparative market analysis, not an appraisal or a mere evaluation. Respondent's first CMA was for $235,000, which is $20,000 lower than the purchase price of the subject property in 2008. Complainant then contacted her mortgage company regarding her concerns about the respondent's CMA, and the mortgage company requested respondent perform another CMA of the subject property. The second CMA was for $215,000. Complainant feels the CMA's value of the property is ridiculous, and the respondent is incompetent and not familiar with the area's property values. Respondent is a licensed real estate broker and is not a licensed appraiser. Respondent has not responded to this complaint. So the expert reviewer's conclusions state, it is of the opinion of the expert review appraiser that the State of Tennessee Appraisal Board does not have legal jurisdiction in this matter because the respondent is a real estate broker and the document provided in the complaint was a comparative market analysis, not an appraisal report. So therefore, the council's recommendation is to dismiss.
All right, you all heard the complaint, and we don't have any jurisdiction over real estate agents. Discussion? All those in favor say aye.
Aye.
Any opposed? Motion carries. Number 4.
2017-013-621. Respondent is the appraisal management company in the above complaint 2017-013-561. Respondent states that they ordered a comparative market analysis for the subject property from the respondent, a licensed real estate agent, in the complaint 2017-013-561 above. Respondent explains that a CMA is not a full appraisal, but is similar to a broker price opinion. Respondent further states that respondent does not determine an opinion of value, but simply coordinates with the licensed real estate agent that completes the CMA, and then respondent provides the CMA to the customer. The reviewer conclusions state the respondent was not acting in an appraisal management company role in this complaint because the person providing the CMA was a licensed real estate broker, not an appraiser. Therefore, council's recommendation is to dismiss it.
All right, you've all heard the complaint. You've heard council's recommendation. Any discussion? All those in favor say aye.
Aye.
Any opposed? Motion carries. Number 5.
Okay. Number 5, 2017015291. Complainant filed this complaint against a respondent based on an appraisal assignment conducted by respondent for a 1004 SFR on a refinance transaction. Complainant's employer is an appraisal company and received the respondent's completed appraisal report with an effective date of October 16th, 2014, and the opinion of value was $252,000 or $252,500. On October 21st, 2014, the lender requested respondent review 3 alternate sales that were not included in the original report, and respondent retransmitted the appraisal with commentary that, quote, the alternative sales were not comparable. On August 8, 2016, complainant's employer was notified that the lender received a repurchase demand letter from Fannie Mae, which indicated that the appraisal did not adequately support the value stated based on 5 reasons. First reason, the comparable sales physical features reported inaccurately. The gross living area was reported as 1,730 square feet, but the MLS states the gross living area is 3,058 square feet. Number 2, the subject physical features reported inaccurately regarding amenities. The report stated property had a 1,029 square foot basement with 803 square foot finished, but the basement was actually 546 square feet with almost 100% finished. Number 3, use of comparable sales with dissimilar site characteristics without adequate explanation. The report used a comparable sale that was situated on a lot that was 12.5 times larger than the subject property. Number 4, inappropriate sales selection due to location. The report used 2 comparable sales that were inappropriate because they were 4.99 and 3.23 miles away from the subject property in different towns, and there were more appropriate comparable sales available to use. And then number 5, use of physically dissimilar comparable sales gross living area. The report used a comparable sales that was 1,096 square feet larger or 56% larger than the subject property. On August 9th, 2016, the complainant's employer provided a copy of the FNMA repurchase demand letter with the alternate comparable sales to respondent and requested her to respond to each of the 5 reasons the FNMA set out in their letter, as well as a response as to why the alternate comparable sales were excluded from the appraisal. Respondent responded to complainant's employer on August 24th, 2016, and it was then forwarded to FNMA, who then issued a second repurchase demand letter and responded to the respondent's response to the first demand letter. On September 21st, 2016, complainant's employer ordered an exterior-only 2055 from a different appraiser and requested it be effective retroactively to October 10th, 2014. This report had an opinion of value of $209,000. Complainant states the subject property's value was between $205,000 and $215,000 as of October 2014, and sold as an REO as of October 2nd, 2016 for $195,000. Complainant's employer believes the respondent ignored sales located in the subject property subdivision that were comparable for sales located over 1 mile away. 2 comparable sales were actually in an adjacent town, and these issues led to a misleading appraisal report and an overstated opinion of value. Respondent responded to the complaint and denies the allegations that she purposely ignored sales of properties within the subdivision of the subject property, denies inflating the value intentionally, and states that she has worked for the complainant's employer and Quicken Loans for several years without issues or complaints. Respondent states that once she received the repurchase demand letter, she realized she did make some mistakes in her appraisal report. The gross living area of the basement was misstated in her appraisal, but this mistake would not have changed the overall value. Respondent also states she should have replaced comparable sales 1 only because she could not verify the square footage, and it was inconsistently listed in the MLS, public records, and by the agent. Respondent states the comparables from a different town were appropriate because they were in the same county, school district, and would have the same taxes, amenities, hospitals, etc. Respondent states the comparables provided by FNMA were not appropriate because they would not be marketed to the same potential buyers. They are of an inferior quality to the subject property, and the entire neighborhood is inferior in amenities and overall appeal. Respondent states she could have used a couple of sales from the subdivision, but it would not have changed the overall value. Respondent also argues that the retroactive appraisal completed by another appraiser was not a full inspection of the property and did not use the comparable sales that the lender and FNMA had suggested either. A full inspection done at the time of the respondent completed her appraisal would have rendered a value similar to the respondent's opinion of value. Respondent states that she has signed up for several classes regarding Fannie Mae guidelines, as well as comparable sales selection and support, and hopes that she will not make the same mistakes in the future. Respondent claims that the unintentional mistakes she made did not result in an over-evaluation of the subject property. The reviewer conclusions, the respondent failed to understand the methods and techniques, or at a minimum, apply the correct physical characteristics to provide a credible appraisal based on the respondent's selection of sales, allocation of square footage, garage space, etc., in violations of Standards Rule 11A. The respondent committed substantial errors that significantly affect an appraisal because of the incorrect square footage allocated to sale number 1 and the misapplication of square footage for the subject where the garage space was included in the basement adjustment line, and no adjustments were made for garage storage in the garage line. This is a violation of Standards Rule 11B. The respondent used sales from a broad area while ignoring proximate sales in violation of Standards Rule 14A. The respondent did not use such comparable data as available to estimate the difference between cost, new and present worth of improvements in violation of Standards Rule 14B3. The respondent did not communicate each analysis, opinion, and conclusion in a manner that is not misleading in violation of Standards Rule 2, specifically the lack of consideration of more proximate sales to the subject property and of a significant difference in square footage, along with the misappropriation of the garage area and the analysis created a misleading report in violation of Standards Rule 21A. The appraisal did not discuss the difference in quality that is apparent between the subject property and the sale properties utilized, nor did it discuss the difference between the subject property and the comparables, and the basis for derivation for adjustments made or omitted in violation of Standards Rule 21B. The respondent's appraisal did not include the reasoning that supports the analysis and conclusions because the report sets out adjustments but does not adequately discuss or analyze to the point the reader of the report would understand the nature and degree of the adjustments. Specifically, the size adjustment of $15 per square foot is not discussed or supported, and the inclusion of the garage within the basement square footage adjustment duplicates that portion of the property in the adjustment process. This is in violation of Standards Rule 228. The recommendation, council recommends the authorization of a civil penalty in the amount of $1,000 to be satisfied within 30 days of execution of the consent order and 30 hours of coursework. Courses to be decided by the commission. Such courses must be completed within 180 days of execution of the consent order. CE must be above and beyond the minimum CE required for license renewal. Such terms are to be settled by the consent order or formal hearing.
All right. Thank you. You've all-
Welcome. Thank you for bearing with me.
Yeah,
Go with the summary, yeah.
we'll change that, and we'll change that in just a minute. Hang on, I'm just looking something up in use, Pap, here. Okay.
I know, I've got 2 different liquids here. Feel free to stop me next time.
You've all heard a recommendation from council is $1,000 and 30 hours. I guess let's break this down first. Anybody have any kind of comments about it as far as the $1,000? Okay. Now, Let's divide the 30 hours up. Any discussion on what courses?
If I could interject, we went ahead and added on your iPads after the full legal report. On page 68 to 84 is all of the approved courses.
Okay,
As
great,
of the last
great,
meeting, so we can flip
great.
through
Which page?
68 through 94.
Thank you.
And it says all approved courses, so we can pick from those.
I'd like to say, I think, I mean, this individual needs a USPAP course in a terrible way. Excuse me? Well, I would like to recommend at least a 7-hour USPAP, 7 of the 30 anyway.
They have just taken one. Or if not, she's going to have to take one of those anyway. So,
I'll withdraw that.
yeah. She's going to get that whether she wants it or not.
Let's talk about or discuss the 30 hours, please, of coursework.
What are the areas that, of deficiency in this particular?
There's a specific Fannie Mae update course. I
Now-
know that was an issue.
I understand that, but isn't that what she said she was registered for?
She did state that, so I'm not sure. I can follow up with her to find out if she'd taken it, or
No. Whether she has or hadn't, we need to, how much is that as far as hours?
7 hours.
Okay.
It doesn't look like she supported her analysis much either.
That's what I was thinking, yeah. She needs a supporting adjustments course, that's for sure, with $15 a square foot on a $250,000 or a $208,000 or $250,000 house. Okay, you got the courses in there, ladies and gentlemen. She can choose the course, but one of them needs to be supporting adjustments. Cody, can you tell us if that's a 7-hour?
On page 73, that is an online selecting and supporting market adjustments. It's a 3-hour course.
Okay, now, yeah, we need a,
Okay.
Our adjustments supported or not course.
okay.
On
Oh,
page 78.
I think that it only ran to 12,
Oh.
31, 6.
Okay, 7 hours of support adjustments, so 7 out of 30. Still got 2 or 3 more. On page 73, 1709, defensible appraisal practices. I'm not so sure that wouldn't help that individual, her. 73, down the bottom, 1709. A course similar to that one.
There's also one on page 79. Was that the one you're referring to?
No, sir, it was not.
Okay, on course 1976, an online course supporting your adjustments.
There it is. That's a 4-hour course.
That is a 3-hour course.
What number was it?
1976,
Okay, that 1984 is support your adjustments, and it's a
4-hour course.
4-hour course.
And which page was the one?
They're both on page
Oh, okay.
79.
Okay, I think the one we were talking about just before that on page 73, it ended. So,
Okay.
just
These
so
two
you-
continued to
Okay.
2018.
So we've got the 1976.
Or the one 4-hour one, which was
Yeah, I don't think we should be telling her which course number to take.
Okay,
But we should,
fair enough.
right?
On the
Yeah,
topic.
we need a
On the
topic,
topic.
yeah, support your adjustments.
So we've got a support adjustment.
Yeah, support adjustments, and that's gonna be, I see that as both a 3 and a 4-hour course.
And I think there's some 7 out there.
There's one that's a 5-hour course, and there's one that's a 7-hour course. So let's go with supporting adjustments for 7 hours. Rex? Anything else?
And I know you mentioned the use PAP and that she's already going to be required to take that.
Yeah.
Is there, what about the updates or? there's a-
That's a 7-hour
Okay.
update.
Yeah.
Do we?
Because I see a
require
lot of
fif-
use PAP.
Back to the original 15-hour. Update just covers the changes.
Yeah. Going back to the one previous, that there's a developing and supporting adjustments, which is 7 hours, so that covers, right, that covers that, and that's an active course, good. So we've got that. This was a Fannie Mae, not an FHA, so said she was. Yeah,
I saw square footage, the Nancy.
yeah.
Page 73, 1888, online ANSI home measurement.
So let's just recommend an ANSI ANSI home measurement course.
And it ends the end of this year.
Yeah.
I also see one that is a 7-hour course that's common appraisal errors. I don't know anything about that. Yeah, I'm very new to this, but they're,
That might be good because I'm sure she'll probably pick up some of those in the near future.
so I thought it might cover a lot of,
Okay.
that's a 7 hour.
Okay. So that
That was-
covers 21 right there.
Okay, common,
Okay.
so.
And then
supporting
she's going to
adjustment.
take the Fannie Mae she signed up for. That'd be 28. That'd be 4 courses. Can you live with 28 hours instead of 30 hours, ladies and gentlemen? All right, let's recommend, the recommendation would be then to alter council's recommendation and go with 28 hours instead of 30. Anybody have a problem with that?
Can you state those courses again, please, sir?
7 hours, supporting adjustments, 7 hours, common appraisal errors, 7 hours, Fannie Mae, and what's the other one?
ANSI home,
7 hours, home measurement. Okay. Those 4 courses for a total of 28 hours, plus council's recommendation for a $1,000 fine. Any further discussion? All those in favor say aye.
Aye.
Any
Aye.
opposed? Move on to number 6. All you need to do is read the number and your recommendation, and we should have read the rest of it.
okay, I apologize.
That's all right.
2017021091. And the recommendation for a letter of warning.
Heard you all should have you had a chance to read these at home? They were sent to you. Only comment to all these is we're seeing more and more about square footages. And I don't think you're going to begin to see any. Okay, you've heard the council's recommendation for number 6. Does anyone have any discussion? Council recommends a letter of warning. All those in favor say aye.
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 Any opposed? Motion carries for number 6. Number 7,
Number 7 is me, and I'm Robin Ryan, and I'm another attorney, and I'm sorry. But,
we'll pray for you, it's no problem.
thank you. And I don't think I'm quite as generous. I'm looking for blood in a lot of places. But in this particular one, it's number 2017-002891. This particular appraiser, when I read what was reviewed and I read the conclusions, first of all, no work file was provided despite a promise, and it made it hard on the reviewer. Second of all, there was a very serious area, to me a serious error, now y'all may think differently, that page 15 that was presented to the complainant was comparing multiple businesses, none of which were a restaurant, and that's what this particular business was, a restaurant. That was pretty troublesome. The reviewer did find numerous violations of 22, 21, 11, and 14, and therefore my recommendation was a civil penalty of $2,000 for violations of those standards. And in fact, that the work file was never provided, despite saying that it would be provided after a hearing, it was not. There was a trial in this particular matter. This was a foreclosure matter. The complainant was the owner of the foreclosed property, and this has to do with how much money he has to pay in the foreclosure. So, then there were problems. So that is what my recommendation was.
you've heard the council's recommendation in number 7, $2,000 civil penalty.
I have a question.
Yes, sir.
The, about page 15, it says it was improved with a mini warehouse.
Yep.
With 9 buildings and 251 units.
Yep.
But it was actually a restaurant.
Mhm.
Were the improved sales mini storage facilities or restaurants, or was there an alternate use type situation going
Not
on here?
alternate use, it was all a restaurant. That was a total error. On
Okay.
top of that, the comparisons were, none of them were for a restaurant.
No, well, let me rephrase my question.
Okay.
What were the improved sales? Any idea? No. Okay. I was wondering if this was a former restaurant. Sometimes we see restaurants that are no longer restaurants, but somebody puts a vape shop in there or a
Right.
pawn shop. I mean, could it be he used an alternative use type property because the market for the restaurant wasn't there? That's all I'm asking.
Well, he might have, except he described the property itself
Right.
as being a warehouse property, and it was not at all a warehouse
know.
property, not at the time of the review at all.
I understand that, but
I mean, I don't think you could have made that, he didn't
no,
say anything
that's a
about
total
it.
error, and
Yeah.
I agree with that. But what I was just trying to get to was, from the valuation standpoint, what were the comps? But if
The comps were, what the reviewer found that the comps were a church, a fitness center, a motel with a fellowship hall, a service garage, a 2-story office building, and convenience market, but no freestanding restaurant, as was the property
no
itself.
discussion as to why a litany of various, okay.
I have a question, please. Just out of my ignorance, the work file, which violates record keeping, he was asked for?
Oh, yes,
And-
twice.
And he did not provide it?
That's right.
Okay,
That's correct.
okay.
He was asked for it initially, which they're always asked for initially before it goes out for
Sure,
review.
no problem, but I just want to clarify that,
And
that's all.
promised to prevent it, and then I believe the reviewing appraiser even asked again for it, and it was not provided.
Any further discussion? You read council's recommendation. All those in favor say aye.
Aye.
Aye. Any opposed? Okay. Council's recommendation carries on number 7.
Number 8, 2017-010101. This complaint was a bank, saying that there were problems with the failure to follow USPAP on a particular appraisal. And there was a huge difference between $900,000 and $400,000, which were the two different appraisal amounts. The respondent states that the property was in need of TLC and only observed from the street, but it was reviewed by a professional, and the professional did find that the sales comparisons were not properly supported, the site value was not supported, the cost approach was not supported, and that the reconciliation did not reconcile quality and quantity of the data, and therefore my recommendation, since there were multiple violations of the standard rules, another $2,000 civil penalties for a violation of 11, 14, 16, 21, and 22.
All right, you've heard the complaint. You've heard council's recommendation. Any discussion?
I look back at this, the disciplinary history, and we've got a 2011 letter of warning, a relatively recent 2014 consent order with an education component. So it looks like they're not getting the message. Maybe.
Right. Thing that concerns me is in 14, he took 15 hours of site valuation, and one of the reviewer's problem, he states, is site valuation. So maybe he slept through that 15 hour.
Wouldn't be hard to do, would it?
Well, there was a lot of courses back. It was a 15-hour residential report writing, a 30-hour basic appraisal procedure, and a 15. I mean, that's.
But I'm just saying, and
six-
at 15, I mean, that's one of the
I agree.
specific courses that were stated for him that he took, and then he's still violating that, so, or she or him or whoever,
Well-
that individual.
Well, let me be clear, of course, you can do $1,000 per each violation of each rule, so it could be up to $4,000 if you thought that would be more appropriate.
I don't
Oh,
think
this-
we had a monetary penalty the last two times. I think a monetary penalty would be in order this time.
Okay, and
Yeah.
council's recommendation is $2,000. Does, any discussion on that? Okay.
Well-
Go ahead, sir.
My only concern on the civil penalty is you pay it and you're done with the loss of time working too while taking it, but hopefully something positive will come out of it.
Well,
Let me refer you to
that-
2014.
Yeah.
Well, that's a great point, Commissioner.
Yeah.
And that's a great point, because as I was looking at that, I mean, he probably, or she, or whoever, probably spent or lost at least $2,000 in doing all this stuff. This is actually less than what they would have probably been out of pocket the last time. So that's why I'm thinking, if the higher the penalty, the more likely they're going to get a wake-up call. And if they don't consent to it, then we can have them come in and have a face-to-face.
So let me reiterate that it can be up to $1,000 apiece, and let me change my recommendation to a $4,000 civil penalty.
Council has changed her recommendation to move it up to $4,000. It's definitely going to wake somebody up. Any discussion on that?
Now, if they do not consent to that, then we'd be looking,
That's correct.
or could we bypass the formal hearing to an informal conference? We've done that occasionally where somebody talked to them.
I think in this situation, you'd have to do the informal conference now.
Oh, I see.
And the last time we did it, at least that particular time, we just didn't have enough information. There was, no understanding as to how the complaint pattern had
Gotcha.
gone and so forth.
Okay.
And I have not had the experience with this board as with others, but I will tell you that it has been my experience, and I've been doing this a while with other boards. When you have a higher civil penalty, if they're serious, they'll pay it. If they're not serious, they won't. We'll have a hearing. And then maybe suspension and revocation is the right answer.
Council's recommendations on the floor for $4,000. Any further discussion?
Well, does that still include coursework that this,
No, there's no coursework involved in this. It's just a $4,000 civil penalty.
Now, if the commission is in favor of adding courses or changing the civil penalty, this is when we would do that.
Right.
Well, see, their license, when's their license up for renewal? 18. So between 2016, 2018, they're going to have to get 30 hours in. This stuff that they took in 2014 it would be applied to the last licensing
Right.
period. So they're already taking some kind of coursework already. So I think the money, if you want to hit them with another course, I don't know that that's going to help much right now.
Any suggestions other than the $4,000? No. All right. Council's recommendation on number 8 is a civil penalty of $4,000. All those in favor say aye.
aye.
All those opposed? Council's recommendation of $4,000 on number 8 passes.
Thank you. Number 9, 2017-011411. This is a homeowner who filed this complaint and because they were attempting to refinance, and they did not like the appraisal and said it had factual errors and was low. It was reviewed, and the reviewer found no problems with the report at all, and therefore my recommendation is to dismiss.
Heard council's recommendation on number 9 to dismiss.
Move to dismiss.
Okay, motion's been made.
Second.
Second. Any discussion? All those in favor of dismissing number 9, say aye.
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 Any opposed? Number 9 dismissed. Number 10, please.
Number 10, 2017-014371. This complainant was a licensee who reviewed 2 appraisals and states they had USPAP violations. There were numerous complaints in the complainant. The respondent did make a response, but we did have both reviews separately reviewed. And the reviewer found multiple violations in each of the appraisal reports from the various standard rules, income approach problems, reconciliation of problems, cost approach, sales comparison, and site issues. And the various rules were 1.1, 1.4, 1.6, 2.1, and 2.2, ethics rules. Also, so my recommendation was $4,000 civil penalties and 15 hours continuing education. I think someone else added that. With residential report writing and 15 hours of education comparative analysis.
You made a comment. I just want to ask a question. You made a comment. This appraiser was, this individual was an appraiser.
Right,
Is
was a
this-
licensee. Yeah.
Is this for emphasis or past tense?
It's just, no, it's just for emphasis.
Okay,
It's
okay,
just,
that's all.
sometimes
So it's
it
still
just
an
helps
appraiser?
Yeah,
Okay.
it's helpful to know where the complaint is coming
Sure,
from.
no problem. All right, you've heard council's recommendation. Any discussion?
I look back in 2012 and I see the words that are the worst words you can ever see by somebody's name, misleading and fraudulent report. So, yeah, I think that's,
The council's recommendation was, was $4,000 civil penalty. When it says ethics rule, is that a course?
No, it was for violations of ethics
Oh,
rules.
violations
yeah,
of ethics rules.
including
Okay.
the standard rules.
Okay, 15-hour continuing education report writing. All right, anybody have any discussion?
In 2012, they had residential report writing. So we're hitting them again with report writing, hoping that it'll stick this time.
They were, this what seemed to me fairly egregious, and since there were 2 separate properties that had all these same issues in it, it seemed to be the standard in the report writing, which is why maybe this person will still benefit from going through the process again. Maybe they won't.
Further discussion? Council's recommendation on number 10, before we vote, is $4,000 civil penalty, 15-hour continuing education in residential report writing, 15-hour continuing education in comparative analysis. All those in favor say aye.
Aye.
All those opposed? Motion carries. Thank you. That concludes the legal section, doesn't it?
Do you all want that continuing education to be beyond what they normally have to do for renewal?
yes.
Or, okay.
Yes.
Ladies and gentlemen, I'll still let you know that in the likelihood, if not the next meeting you have, but the following meeting, there will be a formal hearing. I do have one coming up to be heard. Sorry. Or in,
The next meeting scheduled for July, and we were going to discuss
July.
possibly canceling it. We won't have quorum, and we are going to
Oh.
try to move toward our quarterly meeting, so it'll be September 18th.
okay, well, then I might not get to it before the end of the year, but I'm trying to get to it before the end of the year.
Okay.
Question, is there any way that I could get a list of those courses that were included in this particular?
Absolutely, yes.
Yeah, that would be very helpful.
And they are the list that's on the internet, that's online for
Okay.
approved. So what we are trying to do, and this is the first meeting, so is download them right before the meeting, put them on your iPad so you have the most recent. And so then Dennis will update them with what we approved today, and there'll be a new version online.
Okay. And just go to the TRIAC site and it'll-
Yes.
Okay. And
Yes.
they're listed somewhere in that site?
Absolutely.
Okay,
As our
thank you.
approved courses, yes.
All right. Moving right along, under legal reports, number 2 is the update on the legislative session. I guess, Sarah?
Hey, which is over. Yay. We had 3 bills that passed that affect us. Senate Bill 1188, which is House Bill 300. That was our administrative bill and included our AMC updates. I brought a hard copy if everybody wants it. This is the public chapter. This is the final signed by the governor if you want a hard copy of it. But I've been working on some rulemaking for this. We don't need a lot of rulemaking. There's nothing that needed to be changed immediately, just some kind of cleanup of our language and our rules for AMCs. I will tell you, since we've talked about AMCs and their civil penalties, there is a section, it's section 13, I believe, in this bill, that gives the commission the authority to discipline, suspend, terminate, or deny renewal of the registration of an AMC that violates applicable appraisal-related laws, regulations, or orders. At this time, I would not suggest making any rules that are specific on that because this gives you very broad authority to discipline AMCs when you feel the need. So anything under USPAP or under any appraisal-related rules that we can cite to, we can discipline them.
So our existing laws or rules, we don't have to change anything because of this. We just have extra powers.
Yeah, so really what happened was when we brought in the new AMC stuff, there wasn't anything that we had in rule that conflicted with it that I feel like needed to be changed immediately. There are a couple of cleanup things we're going to do. Under some of our rules, we need to change some language. They don't call it a controlling member of an AMC anymore. We just kind of refer to any members, so I need to go through and take out controlling. But I'll be working on that in the next couple weeks, and I'll probably send you all a copy of some draft rules since we won't meet again until September and kind of get your feedback on an individual basis and talk to you. One thing that I did talk to management about is we will probably have to define good moral character, which when I talked to my supervisor on Friday, we kind of went the real estate route, which what they do is if you have any discipline on your history from another state, we kind of look at that, and then a felony or a misdemeanor of theft of property, services, or money. So we kind of thought real estate appraisers, there's probably about the same moral character that you want to build in there. So I will draft those rules and try to get them to you soon. The other bills that went into effect, Senate Bill 0279, which was House Bill 0379. This is what prohibits the Real Estate Commission from considering disciplinary action based off a complaint completed more than 3 years before it was submitted. So the appraisal report has to be signed within the last 3 years for us to look at it. If not, we'll just, it'll come through and we'll just dismiss it immediately based on statute. I know last time we had talked about rulemaking doing that, so we've wiped that project right now because we don't feel like we need to redo it since this will be statute, which is effective July 1. So we have that. And then the last one, Roxanne, I believe this was on their iPad.
All of them, I think, were
Okay.
230, which is
Senate
number-
Bill 1260, which is House Bill 0326, Public Chapter 230.
Page 118 on your iPads.
For those of you that have attended conferences, this is the state's approach to handle North Carolina dental. So this authorizes the Commissioner of the Department of Commerce and Insurance or one of her designees to review and approve or veto any rules that they believe are unreasonable restraints on trade. So they essentially already have that power because once you all decide on rules, we route them internally that go up through them and they can send them back. So this just gives them that extra authority to veto them. So just in case we don't want a North Carolina dental situation.
And it's there to protect all of our commission and board members. So.
Right.
So that's basically all that happened during legislative session that affects you all. The next thing is the registered trainee. We talked about this last month. I believe I just need you all to vote on what's on the iPads and approve it. This came by way of the ASC. This was one of their suggestions to change, so.
Starting on page 94, you'll see the questions that Sarah's put together for the governor, red line version of what we're going to present. So if you'll go back to 94, that should get us.
So you all approved this language last month for the red line, but I just have to get your sign off on the governor's questions and all of that. I essentially just explained to him that we had a federal audit and this is a result of that to be in compliance.
All right, what we need to vote on is just staying in compliant with the AQB, right?
Yeah, you just need to, just a motion to approve the proposed rules going forward.
So moved.
Second.
We have a motion and second to approve the page number 94 rule proposal. Any discussion? All those in favor say aye.
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 Any opposed? Motion carries.
This too was emailed. It's got the flexibility analysis, everything that you've gotten ahead of time. Thank you.
Next part we've already covered since we talked about it during the legal report, but I think that with adding this new bill and giving us the authority to go after an AMC for any appraisal related laws kind of broadens what we can do to AMCs. So I think we'll probably see a lot more AMC complaints. I mean, since they did 3 today and I'd only ever done 1 in the last year and 2 months that I've been here, so.
Are you completed?
I'm done.
Okay, I just want to make one comment.
Yep.
The statute bill for the statute of limitations for the appraisers, in case you all are wondering, was Senate Bill 279, House Bill 376. Passed out of the House by a vote of 95 to nothing. Passed out of the Senate Judiciary Committee 9 to nothing. And passed out of the full Senate 32 to nothing. So there was nobody that opposed that bill, and I'm thrilled that that's in effect. Gosh, I gotta go back. Okay, moving back to the agenda. Hang on just a second, trying to get there.
I think we're on review appraisals, new business.
New business.
Okay.
Review appraisals.
If you will go to page 126 on your iPad, so we're going to discuss this request for review appraisals. That information is there, and then evaluations shortly after, and just make sure the commission is.
Rex, we're going to hand it over to you.
Yeah, all you, all on board.
Well, on review appraisals, I brought up in January, and talking with Sarah since then, I just think it would be good for us to clear up our language so that it's clear to perform a review appraisal, standard 3, in the state of Tennessee. It needs to be clear that they need to be licensed in the state of Tennessee.
Now, can I just have a question? When you say in the state of Tennessee, you mean the property is in the state of Tennessee?
Yes.
Okay, okay. So on a property in the state of Tennessee, you have to be a licensed Tennessee, okay, very good.
And there are, exceptions to the employment. If it's a bank reviewer working for a bank, they would have exception to that.
Sure.
So, as he said we discussed, so this would be a statute change, which would never happen until next year because, well, we're out of session. But I've been looking to see if we could get, because we define review assignment in our section, which says prepared by a real estate appraiser in it. Therefore, that means they would have to be licensed if it was a review assignment. Is that the same thing as a review appraisal?
I think, yeah. I
'Cause, I
think
mean,
assignment should be changed to appraisal.
Okay, because it says means an analysis, opinion, or conclusion prepared by a real estate appraiser that forms an opinion as to the adequacy and appropriateness of the evaluation, appraisal, or analysis assignment. So,
But again, our law already says.
Says a review assignment means an analysis, opinion, or conclusion prepared by a real estate appraiser that forms an opinion as to the adequacy and appropriateness of a valuation appraisal or an analysis assignment.
But does that imply in that they have to be licensed in Tennessee?
So when I read prepared by a real estate appraiser, then I go by appraiser, use that definition, and say it's unlawful for anyone to not have a license in order to prepare an appraisal. I mean, you can
but-
get there,
Yeah, you can get there.
but I think what Rex is wanting is it to
You-
say prepared by a
Well, let me ask you this.
licensed or certified real estate appraiser.
It looks to me like the easiest route would be, let's get there by virtue of your opinion. And if somebody challenges that from Florida or California, then let them be the one to prove this is not appropriate. And that way we don't have to go through the statute change, and we already take care of what. Yeah, it's already on the books.
Because I will mention it to management just to see if they think it's worth the fight to do a statutory change.
I mean, we get what we want, and we don't have to fight a statutory change.
Yeah, because I
Yep.
mean,
Now, the other side of that is, not the other side, but if I was a lender, and I agree with, says a licensed real estate, well, there's no caveat for a bank there. So no, I said we don't even have to go there. If it's a bank employee,
if they fall under the exemption anyway,
Yeah,
they're going to be exempt no matter what.
what you might find occasionally is a bank has hired appraiser A over here who lives in Texas, and they go, well, I'm working for the bank. But they're not employed by the bank. They're being paid a direct fee to do a real review assignment for that bank. You know, that's technically not working for the bank. That's you could still go after them, but that would be, if I was in California and I got that letter, I'd say I work for East West Bank. They hired me, and I'm like, okay, still pay stub. They can't, so I mean, that would be an argument they may try to save. I don't think it would hold water.
Well, just to educate myself, if I talk to management, do you have a lot of people that are not licensed in Tennessee doing these reviews?
Yes, I can name. Yeah, I got 3 or 4. I can give you names just like that are working for lenders. They're in California. They're in Mississippi.
They don't technically work for the bank. They're just like a.
It'd be like if you were the bank and you hired Garrison Appraisal Company to do a review for something that you made a loan on, and then you pay him just like you paid the appraiser. They're not an employee of the bank. They're a contracted company.
And that's more and more because banks are required to get review appraisals. Years ago, that wasn't as common.
It is very frequent now.
Do we, I guess, as long as you made a comment a while ago about restraint of trade,
Yeah, and I think that's what I'll run this one up the
so
totem
different
pole
than
just to
getting
make
an
sure that we're
appraisal.
not.
That's not a statute. That's already, that's not a statute that the governor's saying, well, it do this, do that, do this, do that. This is already on the books, so he doesn't have to
Yeah,
go
as long
there.
as they're comfortable with us completely using that and not changing it.
But it wouldn't impact trade at all because I do reviews, Rex does reviews. I'm sure any practicing appraiser here does this. So instead of that particular lender calling Coral Gables or Sacramento, they can call appraiser in Tennessee.
Sure.
And they're getting a more competent individual.
you would hope.
Well, they should be, well, I agree, okay.
I'll talk to them about this and see what their opinion is on if we need to do a statutory change or proposal. And if they say no, then we could put a blurb on the appraisal website that just says, this is a reminder that if you're doing review appraisals in the state of Tennessee, you need to be licensed under the appraisal.
And I think that's what we need to do is be clear.
Yeah, I think once we get the clarification up the
Right.
top, as soon as they sign off on it, I mean, we do that for real estate and stuff all the time. Just put little notifies out, say, this is just a friendly reminder. So, okay.
So I guess the second one's me too.
It is you, yes, thank you.
Evaluations. It was a couple of weeks ago, I led a discussion down in Atlanta, one of the approved courses on evaluations. And one thing I took away from it is a confusion amongst appraisers as far as evaluations. State of Tennessee is a rarity in that an appraiser can do an evaluation. And included in this documentation is an opinion provided from the Attorney General as far as on evaluations. What I had asked and suggested is that it may be good to come up with some clarification, both for legal to be able to recognize the difference and for appraisers to stay out of trouble, just clarifications. And a few questions as far as this Attorney General report. All it states essentially is that you have to state that it's not an appraisal. One thing that I've always been told is you don't put your state certification on it. But there's other questions. What do you do about your qualifications? Does your qualifications then make it an appraisal because you're an appraiser? Just different things like that to sort of clear up some of the confusion, especially in Tennessee, since appraisers can do it. And I don't know what form that would be, if it's a Q&A. But I think there's some confusion. Evals are being ordered 3-to-1 to an appraisal. So and what I hear from bank reviewers, evals aren't going anywhere. So we're going to see more and more of it, just like reviews. I don't know what, if we do a little Q&A for clarification or what.
Let me ask you this: if it, and I've read that statute and the law, it just says it has to be for a specific purpose, and has to be labeled. It's not an appraisal. To me, if it has that on it, I don't care if you put all of this other stuff on it. It meets state law to not be an appraisal. I mean, it seems contradictory, but I mean, it looks like it meets state law. And I know that some of the appraisal organizations in the past, it said, well, if you're a member of our organization, you can't do these. Now, other appraisers can, but because you're a member of this organization, you can't. But I've heard that has, that whole thought process has done a 180. And so now they're saying you can. So
Maybe in reference to what we decided a while ago, you could put a blurb out that said, if you're doing evals, make daggone sure that you state that it is not an appraisal. Just something.
But if it's got your license number on it, but it says you can do it if it meets those criteria and you label it's not an appraisal, then no, it doesn't say. It doesn't say that.
It doesn't say that.
You can no. That's what I'm saying.
Part of the confusion.
What difference does it make if you put your license number on it or not? If you're exempted as an appraiser and the state law says this is your exemption, and then because if I'm doing an evaluation and I'm not an appraiser, say I'm a real estate agent, do I have to put this is not an appraisal? I don't know that you have to, because they're not exempted from that. But the other question is, the lenders want an appraiser to prepare the evaluation. So the intent of the bank is we've got an appraiser. So they're the ones kind of with a subvertive motive, so to speak.
Loans that are being renewed and haven't, they're
But
paid.
some-
The good loans and.
But the evaluations also have certain criteria that you have to do. I mean, if you look at the interagency guidelines, sometimes they have more work required than a simple restricted use appraisal report. And so I prefer to do a restricted use appraisal report because then to do an eval. It's easier in some cases. So
I guess
It's up to you guys.
the clarification and to communicate out there how it would be viewed if someone completes an evaluation, they put their state certification on it, they have their qualifications attached, they have a designation that they put on it, but it states on the front of it, this is not an appraisal. For if a complaint is filed, how would it be handled?
It'll be handled just like that CMA was handled today. I mean, I got on the phone with that expert reviewer and she was like, this is not an appraisal report.
we had this same topic come up. I don't know that Randy was on. I'm trying to think. Maybe I think Ms. Johnson might have been on. But we had that exactly come through. We had an evaluation that got turned in, and I got a copy of this. This was years ago, and we basically dismissed it because they're exempted. Just, I
As
mean,
soon as the respondent tells us, you know, in their response, hey, this is not an appraisal, this is an evaluation, and I'm exempt under da-da-da-da because of, then that's how we'll present it to you all. Now, I mean, if you want to do some FAQs or something, what I would suggest is like maybe you and I work on answering some of these, and then we bring them back to everybody to look at to see if everybody agrees with them. And
That was the one thing I saw. There's frustration on the bank side that they would want, especially in the state of Tennessee, appraisers to be able to do them. But appraisers are reluctant to do them because they're fearful of getting in trouble.
I've only seen it come through once, and it was dismissed immediately.
So if an eval is not an appraisal, it doesn't have to follow USPAP.
No,
Okay.
but it has to follow interagency guidelines.
Right,
But
right.
But that's up
we
to the
don't have
banks to police that.
jurisdiction.
Right,
over
right,
it, yeah.
exactly.
Yeah.
Okay.
but if it's technically an eval, but it doesn't fall under the criteria that's listed for an exemption, then it has to follow everything.
Okay.
So
There could be people doing evals on things that doesn't.
that they're not qualified to be exempt from. So
I think a Q&A like that, or something that says, you know, if you're doing them, you know, it has to meet these criteria for the state to be.
yeah, if you want to throw some answers together and then send them to me, and then I'll compare them to the law to make sure we're.
That'd be a great newsletter article. I think Mr. Garrison could comprise.
All right, commission meetings. Is that you, Roxana?
Yes, it is. Thank
Okay.
you, sir. Okay, so the next, before the year ends, we have 3 meetings on the books, July 17th, September 18th, and November 20th. And this particular commission needs to only meet 4 times a year. And so something to consider, the July meeting right now looks like we will not have quorum. Now, we definitely will have 1 new person coming on board. But to the best of my understanding, legal tried to present the cases far enough in advance that if we went straight to the September meeting, we would be fine with our complaints, and we'd be able to skip that one, have still 2 more to address anything that is needed.
2 more, 2 more above and beyond September, or September being one of the 2?
We could not have the 2, but then we'll look at the dates. The last item on the agenda has the January 18th for our first 2018 meeting date. So in 2018, we can stick to the 4 and make sure that everyone's on board with staying up to date. We have 1 complaint, you said?
Yeah.
That would go over? Okay, we have 1 complaint that if we don't have the July meeting would go over, and so we could.
About this
Oh.
hearing that she wants.
Well, let me check with her. Yeah, I was
Could
going
do
to say
another phone?
she had a little.
We can't have a hearing on the
Yeah,
phone.
she got a little. So I'll go talk to her and make sure she hasn't already filed notice or anything. So
Can that be handled by phone conference?
No, not
it's a-
the administrative.
Okay,
right.
so
Oh, it's
let
an
me-
administrative hearing.
it's it would be a hearing.
Okay, so you said, so if she's done already, does that mean we may have a July meeting?
Yes, if that's the case, then we
Okay.
would have the July and hope we have 2 more appointments to our commission, because for us to be able to have quorum. So we'll have 1 person for
No.
sure. Rex will not be able to come in July for sure.
I don't think I'm not. I know I've got a lot of travel in July. I'm
And
not
Dennis
sure
told me the
exact date.
same thing about you, so that was my reason for thinking we're not going to be able to make this in July.
And if we don't get any more appointments, I mean, we're 3 down right now.
So let's do this. I will update everyone as soon as I know we've got appointments and whether or not we have to have the July meeting. But for that, we need quorum, so. Absolutely,
Let us know.
absolutely.
Okay.
So that you can free up your calendar from July and not worry. Then depending how that goes, if we do have to have a July, then the September may not be needed. We can get ahead of the curve for that one. And then, so I'll update you on that. But with that in mind, you know, it's just difficult for, as busy as everyone on the commission is, to make it to the number of meetings that we had. So I would propose that for 2018, we have the 4 meetings, January 15th, April 16th, July 16th, and October 15th on the book, so that everyone can kind of look at their schedules for vacations and everything accordingly, and have fewer but possibly deal with more complaints at each meeting. Sorry, bring cake. Oh, you know what? I've got it wrong. It's January 22nd. Thank you. January
birthday,
22nd.
Me
Okay,
and Martin Luther
so
worked out
the
a thing.
January date, yes, is the 22nd. If the commission's okay, we will block the room, go with these 4 meeting dates for 2018. Okay. And the last piece, not necessarily the least important, but we wanted to update you that we did receive the appraisal subcommittee's decision on our final, on our audit in January that we discussed, and everyone here was at the meeting, kind of heard the same information we received. So when we received the findings with our final grade, if you will, we were in disagreement of what they had given us. And so we have filed an official appeal and done it in writing, followed all the steps. We don't have, as of today, a decision on what they have marked Tennessee as. It's in the process. So hopefully, well, by the next meeting, we'll have something for sure. But we wanted to let you know that that's kind of what we've moved along the line.
So did they initially, you said a mock yard, did they initially?
That was our thought, even though the assistant commissioner at that point thought that that wasn't even okay, because as you know, one of the big area that they discussed at the presentation of the audit was in our rules and had been, and we'd been doing business that way for years. And so it wasn't necessarily that something had gone wrong, we'd just been following and interpreting it wrong. So we're cleaning that up in the rules to make sure we're in compliance. But other items that hadn't been discussed in front of the commission and us as being important were brought up. So, yeah, we were not happy with the finding.
Well, can I ask a question? Were those rules that they said we were not in compliance with, they had never been mentioned in previous audits, had they?
So the reason they had never been mentioned in previous audits is because they didn't review registered trainees. The ASC didn't prior to, I think it was they started in 2015 and they started after our last audit. So it kind of just, so we didn't really think they should be able to ding us for that one, which in all reality, they didn't, but they got us on some other things.
Well, and that one counted too. So we, back to your answer, we thought we would go down to good, weren't thrilled, but yeah, that wasn't even the case. So we will follow the appeal process.
Very good. Anything else?
No, that is all that I have. I thank you all for
Anybody
your
got anything
time.
else?
Will you send us an update on the schedule here of our meetings in 2018?
Absolutely. Yes, definitely will. And then hopefully at that same time, we'll know what to do with the July dates. And if we don't have quorum, that kind of changes. We'll just run late on a
No
case.
way you can move that to August or something like
I mean, we could,
Sorry.
well, and if we had to, we could
Yeah.
consider moving it to August and then canceling September if we
meeting.
needed to, and then.
When is that hearing that council mentioned has to be?
I just don't think she knows right now. I think she wants to do it in July, but it all depends on what the respondent. Sometimes they file continuances and all of that. So we just need to, I'll actually have Roxana go talk to her because.
I'll be happy, to look into that. So you have plenty of time and we don't miss something that important.
Entertain a motion to adjourn.
So moved.
All those in favor, leave.
Thank you.
Anyone who opposes can stay.